Good evening, everyone, and thank you so much for joining us. My name is Michelle Maloney, and I'm the National Convener of the Australian Earth Laws Alliance. It is my great pleasure to have been invited by Alison McCarthy-Phillips and her wonderful crew down in the beautiful parts of New South Wales that she'll tell you about in a moment, to share with you a bit of an introductory talk about rights of nature and earth laws and what's possible in Australia. So in just a minute, Alison will introduce herself and why her area or her group of folks are particularly interested. But we know we've got people joining us from a whole bunch of different places. So over to you, Alison. How are you today?
I'm fabulous and I'm very excited to be here.
That's great.
So my name's Alison McCarthy-Phillips. I'm a co-founder of Mountains for Wildlife, and we are a small volunteer-led group, non-profit group based in the Hawkesbury Blue Mountains. Our members are committed to taking local practical action to protect nature. We've teamed up with the Hawkesbury Environment Network and the Australian Earth Laws Alliance to bring you this webinar. And on behalf of Michelle, Sarah from AELA, Danny, Sarah, Alexander, Matilda, Nick, Alistair, and many others from our groups, we're really excited to be bringing you this conversation, and we warmly welcome you. At Mountains for Wildlife, we believe everything starts with a conversation, with people getting together and organising for positive change. And we hope from this webinar tonight, we can form a working group to progress the conversation within our broader region, that we can inspire environmental groups to make and publicise position statements in relation to earth laws, rights of nature, ecocide, and legal personhood as a way to normalise the ideas and mainstream the conversation. And we can share our inspiration of the many things that are already happening, including on our doorstep with the Blue Mountains City Council. But first, I would like to acknowledge the land on which we're gathered. And for us is the Darug, Gundungurra and Darkinjung people, who are the traditional custodians and caretakers of the lands, skies and waters on which we live. We recognise their ancient and enduring relationship to Nura or country, and we embrace country as kin, including the inherent rights of the land, natural biodiversity and waters to be protected and sustained. When I first realised the rights of nature had found traction enough to turn into an international movement, with multiple countries enshrining enforceable nature-based laws, I was beside myself with excitement. At the time, I was doing postgrad study, living in China, surrounded by air I could barely breathe, and worrying non-stop about the state of the world. Reading about this movement brought me a sense of hope and optimism. I wanted to know how this change was created, and most importantly for me, was anyone in Australia doing it? And sometime later, I discovered the inspiring grassroots work of the Australian Earth Laws Alliance, which brings us to our fabulous speaker tonight, Dr. Michelle Maloney.
Thank you so much. It's lovely to be introduced, and although the work we've been chugging along doing feels really sort of cutting edge and important, it's also been very slow moving. So I appreciate that lovely introduction, but I'm very conscious that a lot of the work we've been doing is very slow and steady behind the scenes, and we're looking forward to getting a lot more traction around core issues in Australia. But before I keep rambling, I would like to acknowledge country too. And so what I might do, folks, is if anyone who knows my presentations, I rely very much on visual aids because there's a lot of material to get through. So please do sit back, relax, and I will share screen and bring up some slides to tell you all about rights of nature around the world and the complexities and the opportunities of doing the kinds of legal reform, governance reform, and community-based activism that we see in many other places. So let's get started. So tonight, as I mentioned, I will talk about a whole bunch of interconnected concepts. For now, we'll shorthand them and call them rights of nature, earth laws, and legal personhood for nature. And for those who've heard my talks before, you'll know a lot of these different concepts. But for anyone who's new, I'm going to make sure that I explain or introduce them as simply and clearly as I can. And there's always so much more that can be learnt and read and gleaned from other presentations. So first, I'd also like to acknowledge country. I'd invite everybody actually to pop into the chat whose country you're on and where you are today or tonight. It'd be lovely to see the diversity of where you're from. I'd like to acknowledge that I live, work and play in the beautiful lands of the Cubby Cubby peoples. And that beautiful image is of the Glasshouse Mountains. So Cubby Cubby country connects with the Glasshouse Mountains in different ways, and the Jinnaburra peoples are the traditional custodians of that place that I see when I walk up my hill and look out. So I really would invite you all to, contemplate or take a big deep breath after your busy day and have a think about those special places, creatures and plants that you love and that you enjoy in your place. Because for me, that's what all of our work is all about. And if I have to share a story, it would of course have to be about a blue-banded bee. In my humble suburban garden, I have at least 3 or 4 current residents. And this afternoon, I sat for a good 10 minutes watching them buzz about doing their buzz pollination. I think they're one of the most delightful neighbours anyone could have. I don't often introduce myself because a lot of the work I do is sort of low-key and quiet, but let me just tell you a little bit about why I am giving this talk tonight. I was born and raised in central Queensland, but I wandered off to ANU and did law and politics and history. And then many, many decades later, went and did a PhD in law as well. And it was actually during that time that I was doing the PhD, which I started in 2008, that I began to engage with earth jurisprudence, wild law, rights of nature. Before that, and after graduating in law, I started working in a whole range of different government departments and other NGOs and volunteering. So I have been around the ridges working on environmental issues, sustainability, environmental law, climate change, and in the last 15 years, what we call earth laws, which I'll define for you, since about 1987. So I'm starting to feel like the old girl in the room when I go to certain things around earth laws and rights of nature. But that's good because it's given me a lot of insights into what's working, what isn't working, and how we need to be creative and passionate and committed. If you want to know more about me, you can visit one of our websites. There's bios there. Perhaps the only other thing to mention in the context of this evening is that I've been involved with the Global Alliance for the Rights of Nature. It's my great privilege. Originally on the exec committee and now in the advisory group. But I'm also connected to a whole range of other wonderful people around the world, including through the Global Tapestry of Alternatives, the emerging Asia Pacific hub for the Global Alliance for the Rights of Nature, which has got some amazing people looking at rights of nature in really different cultural contexts. And all of that work has really enriched the way I look at kinds of things that are possible in Australia. So in our talk, and I'm going to try to whiz through stuff because my goal tonight is not to turn you into an expert, but for those who are new to the topic, really touch on some core concepts, some of the differing things that are emerging, and perhaps point you to other resources, because this is the kind of material that if you start to get curious, there's a wonderful array of things to get into further. So I'm going to talk about what rights of nature are, why have they been created, and how do they work, and some key questions to really think about when you start digging into this space. Because as a general idea, it's very nice, but it's in the specificity, whether it's law or a declaration or a community initiative, it's in that specific kind of detail that it really starts to get interesting. I'm also going to take a 5-minute sidestep and remind people about the Western legal system that dominant Australian law belongs to, and why in a colonial country like Australia, rights of nature is, if nothing else, an invitation to think beyond the way current law works. So that's going to be a fun little adventure. And I will, of course, I'm going to run through a selection of different approaches around the world. I often say that when I started out getting fascinated by this stuff back in 2008, 2009, there was only one example that I knew of at the time of rights of nature laws, and that was the Ecuadorian Constitution. I then discovered that a lot of the rights of nature stuff had started at the local or municipal council level in the US, but that was about all we had. And then after 2016, 2017, everything changed, and I'll tell you why. Lots of different approaches exploded everywhere. So this is what I'm going to try to cover. My apologies if you feel it's a little quick, but as I said, I want to give you a taste of the bigger issues. And if you're interested, whether through your own working groups or other community work, we can dig around and discuss things more. Um, just to let you know, I've introduced myself, but AELA is a very small, not-for-profit organisation, and I want to acknowledge the wonderful Sarah Bashforth is joining us tonight. She's one of my partners, I was going to say partners in crime, partners in environmental love, and we are a small organisation that provide a lot of information, education, awareness raising, and community support, as well as some quiet advice to governments and others who come and have a yarn about what kinds of systems change we need to build an earth-centered society. And that beautiful image there on the right, we're very multidisciplinary. We focus on the structural reform because we're interested in those issues, but the cultural, community building, and alternative creation, ways of thinking differently about how we live, work, and play together on this remarkable planet. Our inspiration is important to share with you so you know our biases and where we come from. Literally, the origins of AELA were a group of us really connecting around Earth jurisprudence and a book called The Great Work, Our Way into the Future, by a lovely older white gentleman who has passed away, Thomas Berry. And it fits into the realm that some people might call Western deep ecology. Others connect him with theology and lots of other things. But there's a wonderful collection of works in that space that are inspiring because it's really Westerners pushing back at some of the flaws in Western law and governance that have brought us to a place where our environmental foundations are in trouble. But of course, being in Australia, we're very privileged to have relationships and friendships with people who continue the knowledge systems of one of the oldest continuous cultures and legal systems on Earth. And for anyone who knows my work, we do a lot of work with different Indigenous friends, including, and I'll mention folks in a moment, Mary Graham and Ross Williams. So rights of nature and earth laws is actually about trying to build fundamental systems change. It's trying to say that a human-centered perspective and a human-centered legal or governance system is not a way forward, because it's that system, that hierarchical notion on the left, seeing everything for humans and then rating other animals based on their brain size or their likeness to us, that has in fact brought us to a place where we don't respect nature in the kinds of activities that we get up to. So we're interested in earth-centeredness, which is literally the idea that all of life on Earth is crucial and critical. It's all interconnected, interactive, and supporting each other and our systems. So I just wanted to mention and honour some of the people that I really owe an enormous debt of gratitude to in terms of my learnings and connecting knowledge in this country to a decolonising way of thinking. And I say that with great humility. I don't pretend that I know anything, but I'm really excited about the prospect of what people like Margot Neal call a third archive, respecting the most remarkable culture and legal system of Indigenous peoples of this country, understanding Western law and knowing that there is something we can do in Australia that is very special, and some new things that we can do to push back at the bigger problems within Western law, obviously without culturally appropriating anyone else's approach, but learning and sharing together. And that's what Future Dreaming, our other sister organisation, is all about. And of course, honouring Mary Graham. If you don't know her work, please do look her up. Her work on the relationalist ethos and the core elements of that are remarkable and wonderful. And she and I are still trying to finish our book despite being incredibly busy. But all of this background is important, because when I start to talk about rights of nature, you need to understand my bias is how do we do new things in Australia without repeating patterns of colonialism of the past? So we'll get to that now. So what the heck are earth laws? I want you to know that when I talk about earth laws or earth jurisprudence, I'm actually using it as a general framework. Earth jurisprudence is just a flash way of saying what Thomas Berry used to say. Jurisprudence is like a theory of law and governance. It's a theoretical thing. If you've got a feminist jurisprudence, then you're looking at law and governance from a feminist perspective. So if you've got earth jurisprudence, you're looking at the whole system, not just environmental law, from an earth-centered or life-based approach. Now, I say earth laws because it's shorter and not quite as long as earth jurisprudence. What does that mean? So earth jurisprudence is a wonderful theory, and I strongly recommend that book, The Great Work. It's absolutely wonderful, and it outlines Berry's critique of these underpinning structures of industrial society. And he points to law, economics, education, and religion as playing a part in the anthropocentrism or the human-centeredness of Westerners generally. Um, and what's emerged in this earth laws space are other theoretical frameworks like ecological law and eco-jurisprudence, and also these really big spearhead concepts like rights of nature, legal personhood for nature, and there's a whole bunch of other things we'll talk about, and also ecocide. AELA has been engaged in and learning from the folks running the big international campaign to get ecocide recognised as an international law, and it's very much a criminal law approach to respecting the living world. So today we'll just focus on rights of nature because there's enough to get into. Why is the other side of this wonderful earth laws umbrella a bit blank? Well, again, and this is why that introduction matters to me and hopefully to you, in Australia, up until 1788, a pre-existing legal system had emerged and been grown out of um, the law of the land, one of the oldest continuous legal systems in the world, which a lot of people disrespect by calling it just custom or um, lots of different words that don't respect it as a legal system, whereas others who know that law is law. And that's why we're going to take a quick sidestep shortly into what the heck is Western law anyway. So we'll talk about that very briefly. So the other side, and this is only my interpretation, the other side of thinking about earth-centered law is deep respect for the remarkable governance system that was grown up in this continent and in other places by First Nations peoples. And as I said, Mary Graham particularly articulates the relationist ethos, the law of obligation, and other concepts really great. And Anne Paulina, who many people know as well, I'm sure, talks about first laws, the law coming from what the land can provide and what we owe to it. So that's a bigger framework for all of the earth laws ideas, and there's a whole lot more concepts and frameworks. If you're in academia, you might even group multi-species justice and lots of other concepts in there. So let's dig right in. What I want to do now is explore some key questions to look at what rights of nature and legal personhood for nature sort of are. But I really want to keep reminding you that what they sort of look like and what they are in other places is completely up to us in Australia as to what we turn some of these ideas into, if anything. And there's lots of other ways to also care for the living world, which we'll talk about. So what I wanted to mention, or what I want to talk about is what are rights of nature laws? That's actually a simple definition. Why have they emerged? And that's where we do our sidestep into you have to understand the flaws in Western law when it comes to how Western law sees nature or the living world. It's really helpful to think about that, truly understand why rights of nature has emerged. And then we're going to talk about a bunch of examples and some questions to think about. Okay, so if you're busy tonight and you want to jump off, this is the simplest way to think about what rights of nature laws are. They are, in simple terms, laws that aim to change the legal status of nature from being human property to being recognised as rights-bearing entities of their own. Why does that matter? Well, as I'll explain very briefly with a very fast history of Western law, or at least examples of what is not Western law, Western law, for more than 2,000 years, has really, through its very many different emergent ideas, has always focused on protecting human property. From the early days of Roman law across Europe and into the UK, until Roman law left the UK and the UK had a muddled mix of Anglo-Saxon emergence of law, right through to the Norman invasion and onwards and upwards through all of those kings and queens of England until the British law came to Australia in 1788. But the absolute heartland of the legal system was protecting property, private property, and especially the property of the elite. And that's a whole nother discussion, whether you look at who the convicts were that were carted to Australia. Most of them were involved in property theft from rich people. Some were a bit more violent. Or whether you look at Victorian laws that protected hierarchical structures in society because human property and wealth had to be protected. I cannot stress enough that notions of private property are at the heart of Western legal systems and the heart of our economic system through capitalism. But even pre-capitalism, the systems were perpetuated to protect property. All right. So that brings me to the bigger question. Well, okay, why have rights of nature laws emerged? In some ways, a lot of the Western thinkers and writers see it really as the next stage of evolution in what we might have considered environmental law. But others would say that earth laws advocates suggest that environmental law has literally been tacked onto, as I said, thousands, hundreds of years of Western style property law and other legal systems. And if you think about environmental law today as the stuff that emerged in the 1970s from the US after the Stockholm Declaration and things, then it's a very new development on top of a very ancient property-focused legal system. And many people say that environmental law still treats nature as an object for human use. It can protect it, or it can use it, or it can exploit it, or it can allow you to take it. But the living world is not seen as a rights-bearing entity. Now, I've touched on this several times. So my quick sidestep is, and I often say, the last thing a fish will notice is water. And often the last thing Westerners in particular, but lots of people would ever notice are the systems they've grown up in. So bear with me, this will make sense. This is my quick way of reminding us that the legal systems we have today haven't always been in place and haven't always been in place in all of the places it exists now. So imagine the world in 1400. And if you don't know your history, you know that 1400 is a little bit before European colonization. And if you haven't seen these maps before, they're pretty cool. This is an estimate of what North America looked like before it was invaded by European powers. And that's an estimate of what it looked like in South America, again, before European colonization. Africa has a whole bunch of different ways of looking at different empires and communities and tribal groupings, and it's been done very bad injustices in so many ways, including understanding pre-colonial geography. And of course, Australia. So what? What I want to tell you and remind you is that prior to the colonial invasion of these places, they all had their own legal systems, and they were nothing like our Western law. So hold that thought, because what then happened is, and I'm sorry, that map's not very good. This is Europe in 1450. And remember, it's around the late 1400s and the early 1500s and beyond that the Europeans first started. So nation states only existed since 1648. Our modern legal systems are very new, but built on old foundations. So the thing I wanted to remind you all, and why it matters with regard to rights of nature, is if you talk about rights of nature to, say, a First Nations person who's never heard of it, and I have done that in the years gone by, they would say to me, why does nature need rights? That's just silly. Nature is the mother. Nature is first. Well, it's important to know that when the European powers started trading with and then invading and claiming all of these places around the world, that's how Western law has spread to the point that these private property-based systems have enabled a different way of looking at the world, a different worldview. Western law is now seen as a norm, and in Australia, people very rarely think outside of it. So this is just an example of all the places that all the European places colonized and brought Western legal thinking. And this is the British Empire, which claimed Australia, and it's the Western legal system that rights of nature is pushing back against. So please hold that thought in mind when I start talking about all these machinations and ins and outs of rights of nature. It really helps to understand why some of these concepts are emerging. And the reason it matters is because if you're trying to find new ways of doing things, you have to understand that the Western legal system was never designed to care for the environment. I know that's a topic of debate. People will say, oh, but early agricultural and peasant societies, sure, but they weren't profoundly earth-centered, they were very practical, and they were built around productive use of land. So, why have rights of nature laws emerged? Often it's sheer desperation. Communities are finding there is literally no other way to start framing a new conversation to stop bulldozers knocking down trees for new residential developments, pollution going into rivers, continual extraction and carbon emissions, etc., etc. So let's get back to why you really joined, not for a history of colonisation. Rights of nature in 2010, 2011 was seen as an unusual oddity, just a South American sort of thing. It bubbled up in Ecuador and Bolivia. And there were these US communities that were doing it out of absolute desperation, trying to stop corporations coming in and wrecking the joint where they lived. Then in 2017, New Zealand, under a completely different process, which we can talk about if we have time, not framed as rights of nature, suddenly announced to the world this remarkable thing that Australians actually paid more attention to than anything at the time that was happening in South America. And this was New Zealand saying, we're giving this river, the Whanganui River, the same rights as a corporation, same rights as a legal person. So that's where legal personhood rights come from. And I'll talk about all that. After 2017 is when we saw a massive explosion in what some people call rights of nature and others call legal personhood. Okay, but I'll explain the differences in a moment because it's really helpful to have a basic structure in your mind about all these different things and how they work. So, when it comes to anything about rights of nature, these are the questions that you should be asking if you're interested. If you're interested, who or what has rights or has the rights that have just been made? What rights does it have? Who can enforce those rights? And what difference or what impact does it make? So let's run through some of those basic questions by using examples. But just before we do, again, and this is Michelle Maloney being annoying about deconstructing our assumption that Western law is the only law. If you look up Wikipedia, and as a legal scholar, it's actually one of the better definitions of rights, believe it or not. It says that rights are legal, social, or ethical principles of freedom or entitlement. Freedom or entitlement. So rights are something Westerners love because we're quite argumentative. We love to say, you can't do that. I have a right for you to not come onto my property. I'm going to sue you for trespass. I have an entitlement. I am allowed to use this land freely. It's mine, mine, mine. And what it says here is rights are the fundamental normative rules about what's allowed of people, etc., etc. And then rights are often considered fundamental to any civilization, for they are regarded as established pillars of society and culture. What I want to remind you is that there are many other cultures around the world that do not have a focus on rights. Many First Peoples, their culture is based on obligations to each other and to country. Now, of course, rights and obligations fit together, but in Western law, everything's, human rights and environmental rights and etc. So again, keep these ideas in mind. Wise use of legal tools and frames and concepts comes from having a vague understanding or a good understanding of what they mean. So rights in Australia and in other Western-style countries and other places that have had Western-style laws forced upon them, rights are very important. And that is why rights of nature is this wonderful concept that actually jolts your average Western-style thinking person to go, what? Why does nature have rights? Only people have rights. And then you can have, as Alison nicely said, a conversation. So, different ways that nature is being recognised as having rights. All around the world today, there's an amazing mix of different ways that the legal systems and community declarations, which may not actually be law, but communities are stating what they want to do, are using a rights of nature or legal personhood approach. So these pictures just remind us that in Ecuador, when they passed their new constitution in 2008, they said that all of nature across their whole country have rights to exist, thrive, and evolve. So the whole jurisdiction, rights of nature. But as I mentioned, after New Zealand and its very unique combination of reasons, which I'll tell you a bit about, was able to say in its own legal system that a river and a forest, and more recently a mountain, have their own legal rights. That's because these agreements emerged out of the Treaty of Waitangi between the Maori people and the government of the day. And they've come from a very different place from rights rather than rights of nature. They come from what some would call cultural rights. That in Australia, you would think of them as native title rights, but they're not. They're a unique thing for New Zealand. And that the underpinning structures that support those laws are quite different. And again, I don't want to lose folks if I ramble on about the detail, but there are some really different ways that people are doing this stuff. I'm going to talk about Colombia in a minute when they looked at their river and did some cool things in a court case. The other thing is that separate to what I would think of as core rights of nature movements, there have been different jurisdictions around the world that have tried to recognize the rights of particular species. And that's a whole nother conversation, connected, but also connects in with other concepts like animal rights. But under the rights of nature banner in the US, the Ojibwe First Nations people declared through their system of law that wild rice was a sacred and important spiritual and material thing in their culture, and that it has the right to exist. And they've actually used that declaration in their own legal system to try to challenge unwanted developments. So rights of nature is bubbling up in lots of different places in lots of different ways. Now, I'm going to use a tree analogy again, and I apologize, it's not the clearest photo. And I know anyone who's seen me talk before has probably seen this wonderful tree. But let me make it simple as to the way to think about what rights of nature tools are popping up. So think about the big trunk of a tree as the image in your mind that what's trying to happen is new things are growing up, trying to say that nature is not just human property, invisible in Western law as this background thing. The whole chunk of idea is nature is a living being and it should have its own right to exist in the Western or other legal system. So that's the big idea. But then what we see on one big branch is when you see rights of nature, or you declare or you make law that rights of nature exists across an entire jurisdiction. That has an entire body of law that's quite different to legal personhood, right? We can come back to that if people have questions. So think of that, rights of nature across a jurisdiction, Ecuador. It's the easiest one to hang on to. Then you might say, well, we're not actually capable or interested in putting rights of nature across a whole jurisdiction. Let's say you wanted to do it in Australia and went, well, God, I'm trying to get the federal government to do something under the EPBC Act, blah, blah, or New South Wales. But what about these other tools people are developing? So think about on the left side of the big branch, you've got across a whole jurisdiction, and that often means open standing. So anyone can speak for any part of nature. On the right-hand side, we've got this other big branch emerging saying, well, actually, people's relationship is often with their local place, their local ecosystem. One way to do that is to declare that this ecosystem has legal personhood, which is a slightly different construct to actually we want to say our ecosystem isn't just a legal person, which only has the same rights as a corporation to sue and be sued and to own property. We think it's more than that. And this is where the Colombian example came through and said, in a court case, oh, this river is not a legal person because it's not a person, it's a river. It's a subject of rights. It has river rights, and they articulated what those rights were. So again, big chunk of idea is changing the legal status of nature. A couple of different ways to do it. These are the most established, the most solid. Wonderful ideas have come out of the work of Anne Poelina with the idea of, well, in first laws, in Aboriginal law, if you were going to translate that into Western rights of nature, you would say there were rights for ancestral beings, as well as the river system they live in, for example, to exist, thrive, and continue and persist. So there's all these different ways that we can explore and understand this movement. There's also lots of different ways where here in Australia, we might play with ways to go into this realm. And the other thing I want to mention on that other little branch is then, as I mentioned with the wild rice, there are different ways to look at the rights of individual species, if that's a direction you're interested in. Okay, I'm going to move really quickly through these examples because I think I've laboured the point. There are lots of different ways. And really, there's so much that if you're interested in, I can provide more reading, or we can have further conversations, or you can look up other wonderful activists around the world and explore what they're doing. So different ways, I've already said that, and I just want to keep harping on it because a lot of activists are thinking, how can I do this in Australia? So the question is, do you want to try to do it across your local council area, state government, across a jurisdiction? Do you just want to look at really sort of simple first steps in legal personhood, which have a particular form in law already? Or do you want to explore ecosystems being a subject of rights? What does that look like? And then, which we'll talk about briefly, a wonderful example in Australia, the Yarra River, setting up a law that recognised that river as a living being. Sort of not technically a rights of nature law, doesn't give that river its own legal rights, but it is a very, very important law in Australia, and an important beginning and initiative. I won't go through that slide, it's too frightening. And if you hear growling, that's my dog. I do apologise, it's not me. He thinks he sees a scary neighbour. Okay, so rights of nature across the country. I won't labour this point. There's so much in this, but it's really fascinating. By putting it into their constitution, they then created open standing, as I said. Anyone can bring a case. There have been dozens of cases brought in courts in Ecuador. Many of those cases have found successfully for nature, which is pretty cool. And there's a whole bunch of other things we can talk about. I'll move on. If the legal personhood sort of movement has really taken off with rivers, you've probably seen that. All I really want to share with you here, so I don't go into too much detail, is that legal personhood is sort of different to a broad-based rights of nature, but there's many similarities. And legal personhood constructs, which have been around for at least 600 years, maybe a lot more, legal personhood is often seen as an easier first step for Western law, because that's the kind of construct used for not just corporations, but municipalities, governments. Anyway, so there's lots of different ways to think about legal personhood, which we can talk about. And as I say, the New Zealand example, the Whanganui River development, the legislation is rather beautiful, talks about the river. There's lots of intricacies to how it works, but the thing I want to stress to people who are trying to think practically about this in Australia, when people go down the ecosystem approach, they nearly always look to create guardians to either care for or speak for or legally represent that ecosystem. The same way that you have a board of directors who can speak in court for a legal person, which is a company, a lot of these ecosystem-based approaches have got guardians. Very rarely would you see guardians set up when you've got something like what Ecuador has, because how do you set up guardians for the entire jurisdiction? You could, there's intricacies to that, but really the guardianship idea is really important for legal personhood or ecosystem approaches. I'll jump through, there's lots of examples bubbling along with rivers. Oh, what a great pun. Magpie River, legal personhood via twin resolutions by the local municipality and the local Inuit Council, which is an amazing initiative. Subject of rights in law, I briefly want to mention Colombia because communities were worried about horrible things happening to their river due to large-scale extractivism, mining and such. The court, not a legislation or law from the government, but the court recognised that the Atrato River is an entity subject, which is the subject of rights. They did not talk about being legal personhood. It was much broader than what legal personhood rights are. So they talk about a right, including having rights to protection, conservation, maintenance, and restoration by the state and communities. And so they set up a system, and I must check back and see if there's been any actions under it, with one man and one woman from 7 villages being the representatives, plus someone from the government. So again, guardianship. I'm going to skip through these because there's examples everywhere. The recognising ecosystems as a living being. I just wanted to mention again the Birrarung Council and the Yarra River Act. Really important Australian initiative. All right. I'm going to jump up. Rights of specific species. I've already touched on Manuman, the rice, which is wonderful. But also more recently, apparently, there is a treaty amongst Pacific Indigenous leaders recognizing whales and dolphins. It's been a bit contentious, but it's a fascinating development, potentially really important. Okay, so I want to make sure we have at least 15 or 20 minutes of questions, and I'm over a little bit. I apologize. But what I wanted to quickly mention is the Australian legal system today is a place that is a system that's, on the one hand, incredibly stable. You know, we don't have revolutions. We haven't changed our constitution. I think it's one of the oldest continuous written constitutions in modern law, because other countries have changed their constitution several times in the 20th century. That makes it a stable sort of system, but it also makes it really hard to do significant change. But we have three tiers of government, and each one is responsible for slightly different things. Doesn't make it easy, but what I wanted to just say here is who has the power? Well, it depends on the domain or the issue. And communities around Australia, for more than the decade that I've been talking about these issues, have dabbled with some of these ideas, but find it very, very hard to get traction. That's not to say it's not possible, but what is it and what are we talking about? So local councils, technically speaking, don't pass environmental law and probably wouldn't pass rights of nature laws as we know it, but they could. And there's different rules for different councils in different states. They can push the boundaries. And certainly if you got a group of councillors who really wanted to push boundaries, they could engage in some of this language and explore some of these ideas. State governments, as we know, particularly the one I'm in, they are, I shouldn't laugh, profoundly locked into extractivist policies and approaches. Trying to get a rights of nature bill or even discussion into Parliament would be remarkable. We managed to get a conversation into Western Australia back in 2019, thanks to Diane Evers. It's a whole nother story. We knew the legislation wouldn't go through, but at least they've got it in Hansard. Federal government, whole nother, I was going to say ball of wax, kettle of fish, mixing my metaphors, but there are ways and means to do things. Now let's come back to an anti or a decolonial way of thinking. Okay, we want to do something ourselves in the current Western legal system. How do we do that without perpetuating colonialism? This is a tricky question because we can't just say to our Aboriginal mates, well, we recognise your law, we wish your law was in charge of things, when you've got the power of and the potential violence of the state, the police who, you know, come out and protect places like mines and other places when innocent protesters are coming out to try to change the law, particularly with a decolonising lens, has its challenges, but it's not impossible. For me, and I really want to admit this is my personal bias, what I'm really interested for anything around rights of nature in Australia is there are ways that we can push at Western law. Communities can draft their own declaration for the rights of their river. They can draft laws. We can help you with that. You can push for law reform. I wish there was a movement in this country pushing for deeper ecocentric law. However, issues to consider: what are the first laws or ancient laws and ways of caring for relevant places? You know, what are the local Aboriginal people's continuing law and obligation to a place? What of that can they share with non-Indigenous people? What could be a third way where we could build something together? And this is exactly this place-based collaborative ecological custodianship is exactly what the ancient legal system on this continent was all about and is all about. So if, as Australians, what we're really interested in is healthy places, is the question, how do we do rights of nature? Or is the question, how do we do this together where we can respect ancient law, develop a new or shared language, respect the laws of obligation, but really stop thinking like a Westerner where we have a law to go across a big thing and think about place-based laws? Because the thing that I love about Aboriginal peoples and other First Nations peoples' laws is they were, if you lived in a desert, the law of the land was how do you live in a desert? What is water? What is land? What are caves? If you lived in a jungle where water wasn't a problem, how do you share those rainforest fruits? How do you make sure that what you're doing sustains that jungle? So the specificity of local places, especially in a place as big as Australia, and given the ancient system, is absolutely fascinating and very rich with potential for community conversations, which again comes back to what Alison said. I just want to give a quick plug for Green Prints. What we're interested in AELA is bringing all of these cool ideas together in a third way, but really asking, how could we push the Australian Western legal system to give greater rights to local people to be custodians and stewards? Because that's one of the biggest problems in the system. Everything comes from top down, and we all scurry around spending a lot of our time trying to stop unwanted developments. So I know I've talked a bit over time, but I hope that that was material for lots of thinking. And yeah, I know Sarah's been collecting any questions if people have them. So, Sarah, have there been any questions that I should go to in a document?
Yes, we've got a question from Michelle there.
Oh, good.
Hello,
Excellent.
Michelle.
Wow. Hello, Michelle. I've fried everyone's brains if we've only got one question. I feel like I should apologize. Okay, rivers and humans are so fundamentally different. Why would you proclaim that a river has the rights of a person? Exactly. I hope that I've answered that since you perhaps asked that question. Um, the story is that in New Zealand, under these very long, I mean, I think I'm correct in that the Treaty of Waitangi enabled Maori people to sue, well, not sue, but negotiate with the government for compensation for loss of land. And one of the longest cases was about the Whanganui River. And at one point, the Maori people would not agree to a compensation agreement unless they got their river back. And the government would not let them have the river. And somebody said, what if the river owned itself? And then no one gets it back, but you can be guardians. So they literally grabbed this legal personhood construct because it was an easier way forward. And it's turned into this, this really exciting catalyst or spark for lots of other things. So that's why I think that's why they latched onto that idea, and then we'll slowly build out from that, I understand. I'm just going to read some of the questions, Sarah. I assume there'd be questions as we went through, but I can read them now as they pop in, unless I miss them. Annette has asked, would be interesting to apply this to the Murray-Darling River. Oh my God, yes. And we supported a citizens' inquiry into the health of the Darling River. I wonder, Sarah, if you could put the link for the tribunal into the chat. And we did a 220-page report, which is beautiful because it actually shares all the comments from Indigenous and non-Indigenous community members. And some of the recommendations we had was about community governance and really connecting with concepts like rights of nature, but in their own way. Are there any precedents for councils in Australia attempting to assert rights of nature? We have one example. The Blue Mountain City Council, because some local people were very active and pushed them to they ended up making a resolution where rights of nature would be considered as an operating principle. This in turn inspired people, other folks around the world actually, including in Ireland, to look at local council powers to look at rights of nature. My understanding is that the council hasn't really progressed that into practical implementation, despite many invitations from us to do so and to connect and rethink some of that. But it's an interesting example, and it's certainly something we can push on. And I've actually got students updating some research we've done on how councils in particularly New South Wales and Victoria and Queensland, because that's where we get a lot of questions from, how councils might engage with rights of nature and how far they could push the envelope, start changing it. Susie has asked, can you explain how the Columbian River example came about, including where the impetus came from? My understanding is that a group of activists, both local Indigenous peoples on the river and other people who were really worried about the river, basically compiled and took a case to the court. And this is really interesting because I often ponder how far we could push it in Australia. But so they basically took a case to the court arguing, number one, that the river was in danger and being polluted and that its rights were being violated, and that it had rights. And so it was really the creativity of the court to make that case and to declare that, yes, the river has rights. Could we do that in a court in Australia? Probably trickier given the common law lock-in with precedent and other things, but all options are available. So the impetus came from activists, the same as what happened in India in 2017, was one of the first countries to look at New Zealand, and a court said, the Ganges River is being treated terribly. We declare that it has legal personhood, but then it was challenged by a number of groups and was no longer upheld. So again, court cases, legislation, they all operate slightly differently. Amanda has said, I suspect natural capital systems and accounting is built on Western law. Yep. Is this true? And is there any way of putting this way of thinking into the equation? That is a really excellent question. Kind of connects to the work we do inside the New Economy Network Australia around the economic system itself. You could argue that the foundation of a society is nature, and that if you account for it appropriately, etc., you could do it that way. However, many people in the rights of nature movement are very anti the commodification of nature and even using the terms natural capital. I'm not saying I'm against it. I think anything that takes us to a further step to caring for places is important. So it's a really interesting and big issue. I'm happy to chat about that more. Irma has asked, regarding declarations as a tool for local communities, only the gas field free declarations come to mind. That's right. Made in WA to stop fracking. What other declarations are communities working on? Great question. So the declaration approach was also very powerful in the Northern Rivers, Irma. So in the northern parts of New South Wales. I am personally in touch with several communities, particularly in New South Wales and particularly on rivers, who are really thinking about how communities might do something like have Indigenous and non-Indigenous people work together on something like declaration of custodial obligations and the rights of nature, where you might find ways to bring together the language and the concepts that are allowed to be shared by Aboriginal peoples who have cared for those places, and connect it with, we are the locals. We have a right to care for this place. We have an obligation to be custodians or stewards, and nature has a right. And if you look at the examples from the USA, when little communities were desperately trying to stop horrible things from happening, that's exactly what they did. Their laws were one page. They weren't complex. And it basically said, the people of Blah County assert that nature has the right to exist, thrive, and evolve in our jurisdiction, and we assert that we have the right to defend nature as the local stewards. And that was pretty much the essence of their laws. And that's, I think, something that has really got a bit of promise for activating communities to connect, to talk. And then I think in Australia, with the powerful industry lobbies controlling so much of our top-down law, I think that some kind of vision and movement there might be a way forward. Deborah, hello, Deborah. As a former councillor, I am now in discussion with new councillors about the work that she did, and I should acknowledge Deborah Maher for bringing rights of nature conversations into the Mornington Peninsula Shire Council, and she and I caused a bit of a stir on some of those local radio shows, having a yarn about things. And so Deborah and I will be conspiring to do good deeds together this year, and Deborah will continue her wonderful work as well. Thank you, Deborah. It's 6:30, folks, and if you need to jump off, please do, but I'll answer a couple more questions, and I might be sneaky and go over 5 minutes because I really want to hand over back to Alison after I have been a wall of sound at you all, because really this session is about getting interest in people connecting with Alison and her group to see what's possible, and all creativity is invited. Pat, what about ocean rights? That's a great question. Thank you. There's a number of terrific things happening. There's an awesome and wonderful earth lawyer called Michelle Bender, who used to be with the Earth Law Center in the US, and she's now with another group. But they're doing a whole bunch of things around oceans. I think she was working with some of those Pacific states too. If you're super keen, I can dig up some references and email them to you. And I'm sorry, I can't give the proper answer, but there are some really great things happening on oceans. And I just want to flag with folks too, if you ever go into the internet, I sound very old, don't I? On the internet, and you find things like Universal Declaration for the Rights of Nature or a Universal Declaration for Ocean Rights. Please note that these are civil society things that have been created to inspire, and they've often been used by local communities to use the wording. They're not UN What I should have said is, at the moment, Rights of Nature is a civil society movement getting traction in different domestic, national or jurisdiction, smaller jurisdictions. There have been a lot of efforts through the UN Harmony for Nature to do stuff within the UN, but it's not officially part of that UN or international law system just yet, which is really interesting, I think. Okay. Trisha, I like the concept of multi-species justice and rights to put humans in their right place and against the perception of humans versus non-humans. Any thoughts on this? Yes, I have many thoughts. The short thought is absolutely we are part of nature. We are nothing more than a happy animal with opposable thumbs who tripped over consciousness. And in fact, we're not even that happy, are we, most of the time? But in Western constructs, and we actually, Sarah and I got pulled up by someone when they spotted our conference name, Ethical Futures for People and Planet. And we actually got an email from someone going, why are you separating people and planet? And I actually had to explain, if you just talk about nature and assume we're part of it, Westerners immediately think you're talking about wildlife protection. So sometimes you've got to play in the framing that people already use. So I absolutely agree that anything that puts humans in their rightful place, and that's really what a lot of this stuff's about, is really powerful. But sometimes you've got to use steps into that by saying people and planet, or, and that's why we've got a webinar series called Exploring Human Nature Connections. And I'm sure we'll get someone else going, humans are part of nature. Yes, we are. Isn't it great? But we articulate that a lot of people think about that difference between humans and nature, and it's a helpful framing. All right, I might just take one more. There are attempts in the US to extend personhood concepts derived from rivers and corpse to apply to animals. Yes, to elephants and chimpanzees. And I had a note about that wonderful initiative. I think one's called the Great Ape Initiative, and then there are a number of different projects and different peoples and groups trying to push for better protection for individual species and even individual animals in zoos. People have taken cases trying to support those creatures. Yep, everyone's saying thank you. Thank you, Brent. Here's what Blue Mountains says about Ron. Keen to push them further. Yes, please. Yes, please. And a number of people have to go. So yes, are there promising hooks through the Sustainable Development Goals? Look, there's always a promising hook. I'm a great believer in grab onto something that's in the world and push it further. The SDGs, the Sustainable Development Goals, are unfortunately still a little bit locked on to development and to growth. In fact, I think they're explicitly mentioned, and I remember the late and wonderful Will Steffen, who unfortunately passed away. The SDGs was sort of trying to build on planetary boundaries, but it was still locked into this growth development idea. So, yes, there are hooks. You can definitely say that to implement this goal for oceans or that goal for protecting life above water, we should look at rights of nature or we should look at legal personhood. Absolutely, you can connect. All right. Which political parties do you think are most interested? Some of the Greens are interested, but I have given talks to lots of different groups, Labor, to some folks in the Liberal Party. Yeah. Now, Alison is saying, if anyone's interested in progressing this conversation within the Hawkesbury Blue Mountains region, please reach out, info@mountainsforwildlife.org.au. And Alison, what I'd love to do is spotlight you again. And if you'd like to unmute, let's just have a 1-minute chat. And we've been very efficient, actually. We're only 5 minutes over, despite all my talking. Did you want to talk about any of the ideas that you guys have been developing, or are you just looking forward to starting these conversations?
We're just looking forward to starting the conversations locally. And obviously there's been a lot of work undertaken to get the Blue Mountain City Council where they got, which is really exciting, but we're hoping to continue it on. And in particular, try to get smaller environmental groups to embed these sort of concepts into the work that we're all doing,
Yes.
and try and sort of change the conversation. So if there's anyone out there interested in joining us, please do get in touch. We'd love to keep the conversation going. But
absolutely. And I just want to say that AELA is absolutely over the moon to talk to any groups who want to start thinking about this or exploring these ideas. And while I can't speak for this initiative that I will mention, I do want to mention, and I did say it to Alison, so she's aware, that the Hawkesbury Nepean water keepers are also looking at some of these ideas. So there is a definite wonderful bubbling up of stuff in your region, Alison. So as you bring in more folks, let's have a chat, and then I'll find ways to connect you all and see what we can dream up. And I do feel that the number of communities I've been chatting to in different river systems in New South Wales could be a really a good flashpoint for some of these conversations. And I'm sorry, I think I cut you off. Back to you.
No, I couldn't agree more. Even I think Joel's here. I ran into him on Saturday and he mentioned there was a whole group of people that came out as a result up to the Blue Mountains as a result of a conversation with a Dutch professor that was all about the rights of nature as well. So there's lots of things happening and it's just a matter of us all connecting. But I just wanted to say a huge thank you to Sarah from AELA for her work behind the scenes organising this webinar. You're amazing, super organised. It was fabulous. And for Michelle, as always, taking her time out at absolutely for free to discuss with us all of these important conversations and concepts.
Thank you, Alison. And thank you for being a catalyst for having these discussions. Really looking forward to working with you and others as we can explore this. Because as I like to think, Australia, we can do a little better. I think we have so much potential. The oldest continuous culture on Earth, one of the youngest colonial kind of places on Earth. So surely, if anything amazing is going to happen, it should happen here. Someone's just asked about the recording. We will work on pulling that together and getting that probably on our website for you. Yeah, so just keep an eye on our website and all of that. But without further ado, thank you for joining us, everyone. Thank you for sticking with us 7 minutes overdue. If anyone wants to get in touch with AELA and have a chat about what's possible in your community, do send us an email. You can send it to aela@earthlaws.org.au. Or if you find me on the website or Sarah, it's Michelle or at earthlaws.org.au or Sarah, etc. And we are super keen to talk to anyone and really super keen to see what you guys with your amazing community knowledge and love of place want to whip up, because I think that's where the real excitement is, with the people who are caring for their local places. So on that note, thank you again, Alison. Thank you, everybody. Thank you, Sarah. I've got to find a better frame than my partner in crime, my partner in events, and we will see you all very soon. Thank you so much.
And thanks to everyone else in Mountains for Wildlife who've helped behind the scenes, sending out emails and organising.
Yes, thank you.
Yeah.
Can't wait to meet you all in person. I'm going to have to find an excuse to come down and see you.
You're welcome anytime at all.
Thanks, Alison.
Okay.
I'll speak
Bye,
to you
everyone.
soon, and others. Thank you. Good night.
Thank you.
Bye.